The Supreme Court just handed President Trump a big victory in his immigration crackdown in Los Angeles, and this ruling will have an impact on how ICE continues to conduct crackdowns across the country. At least for right now, the Supreme Court says ICE agents can continue with their roving patrols, and most importantly, will still have a lot of leeway when it comes to who they are able to legally stop, question, and detain. Today's order by the justices stays or pauses a temporary restraining order that was imposed against the Trump administration by a lower court federal judge who said the Trump administration was likely violating the Fourth and Fifth Amendments of the United States Constitution because of ICE's sometimes aggressive raids. Obviously, the Constitution of the United States says law enforcement cannot just randomly stop you for no reason. And that lower court judge ruled that if federal immigration officers want to legally stop, question, or detain people when it comes to immigration, they could not use any of the following four factors or any combination of those four factors to justify that stop. The judge said ICE agents could not use, one, presence at a particular location like a bus stop, car wash, day labor pickup site, agriculture site, or anything like that to justify the stop. Two, the type of work someone does. Three, speaking Spanish or speaking English in an accent. Or four, apparent race or ethnicity. The Trump administration appealed to the Supreme Court saying if ICE agents couldn't use those factors, it would substantially hamper their efforts to enforce immigration laws in the Los Angeles area. Today, the conservative supermajority of the Supreme Court agreed with the Trump administration. Justice Kavanaugh wrote a concurring opinion saying that all the government needs to justify a stop is reasonable suspicion that the individual is illegally present in the United States. And all federal agents need to have to come up with that reasonable suspicion is a totality of the circumstances. Now, Kavanaugh said clearly that ethnicity alone does not equal reasonable suspicion, but he said ethnicity can be a relevant factor in that totality of circumstances. Now, what's interesting here is Kavanaugh's concurring opinion says he does believe that the totality of the circumstances in Los Angeles are already present. He points to things like the extremely high number and percentage of illegal immigrants in the Los Angeles area, that those individuals tend to gather in certain locations to seek daily work, that those individuals often work in certain kinds of jobs such as day labor, landscaping, agriculture, and construction that do not require paperwork and are therefore especially attractive to illegal immigrants, and that many of those illegally in the Los Angeles area come from Mexico or Central America and do not speak much English. Importantly, Kavanaugh noted in his concurring opinion that reasonable suspicion only allows federal law enforcement to briefly stop the individual and inquire about their immigration status. If the person is a U.S. citizen or otherwise here in this country lawfully, that individual must be free to go after only a brief encounter. All three liberal justices joined in another scathing dissent, saying that the U.S. government provided no evidence that there is an extremely high number and percentage of illegal immigrants in the Los Angeles area. And the dissent also points out that the government's immigration actions are way more aggressive than they're saying in court. And the three liberal justices basically said today's ruling will just give the Trump administration a pass to legally racially profile people. The dissent reads, "The Fourth Amendment protects every individual's constitutional right to be free from arbitrary interference by law officers. After today, that may no longer be true for those who happen to look a certain way, speak a certain way, and appear to work at a certain type of legitimate job that pays very little." This case will now continue in the Ninth Circuit Court of Appeals, and if you want to read today's ruling for yourself, I'm going to email it out to you in tonight's Facts HQ email, so make sure you sign yourself up.